Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may be seated. Whenever you're ready, Mr. Federick.
Sir, could you state your name and spell it for the record, please?
Nicholas G. Bloomfield. First name spelling is Nicholas. Middle initial is G. Last name spelling is Bloomfield. Bloomfield.
Could you tell the jury a little bit what you do for a living?
So presently I'm where I reside is in Farmington, New Mexico. There is a nonprofit community-owned hospital where I reside, and presently I am employed there as a regulatory manager, which means I'm responsible for making sure that the organization is in compliance with all federal and state regulations.
Was that your job years prior to that?
It was not.
What did you do before that?
Prior to that, I did a 20-year career in law enforcement in the state of New Mexico, was a certified officer. I retired in February of 2023.
And in terms of what roles did you have, what departments did you work for in the state of New Mexico?
So I worked for two separate agencies. I began working with the local sheriff's office. After completing the academy, I was assigned to the patrol division where I worked as a patrol officer. After a couple of years, I became a field training officer where I was responsible for training new officers and making sure that they were within compliance of both organizational policy as well as their training so that they could begin practicing on their own. Following that time, I made a transfer to the narcotics division. I did 3 years working as an undercover narcotics agent, where our primary responsibilities were to identify, infiltrate, and dismantle drug trafficking organizations. Following that assignment, I promoted to the rank of corporal. A short time later, I promoted to the rank of sergeant. I was assigned to the patrol division for both of those assignments, where I supervised officers who were working on a standard patrol shift. In addition to that, during my tenure at the sheriff's office, I was a SWAT team member. I did that for a number of years, approximately 6 years or so, and then I became a team leader once I was promoted. I worked at the sheriff's office for approximately 10 years, and then I transferred to our local municipal police department, Farmington Police Department. Went back to patrol there. After being on patrol for a short period of time, I assessed for the SWAT team, was selected to be an operator on the SWAT team. In addition to that, I also went into our training and recruiting division, where I was responsible for basic and advanced training. After that assignment, I promoted again to the rank of corporal and then to the rank of sergeant. As a sergeant, I was assigned to stand up a use of force investigation division within the organization. So myself and another supervisor were responsible for investigating all police uses of force within the organization. During my tenure, I reviewed approximately 200 cases. In connection with that assignment, I was also responsible for developing use of force policies and practices, as well as training related to the use of force. And following that assignment, I was assigned to a special task by the Chief of Police to reach out to and to work with academics in the field of criminal justice. Specifically, we were interested in conducting research related to a phenomenon known as contagious fire within the policing industry. Essentially, that's a situation where the question is when groups of officers are in a situation where they're applying deadly force through the use of their firearms. The question is that do officers fire rounds because they are viewing subjectively what they determine to be deadly force criteria, or are they shooting because other officers are shooting? And so again, the term that is used within the industry presently is known as bunt shooting or contagious fire. And so I was able to reach out to some academics and partner with them from the University of New Haven and conducted research. And so I kind of finished up my time working that assignment as well as a patrol sergeant before I ended up retiring in February of 2023.
Take a little breath there and grab some water.
Thank you.
You just landed from New Mexico too, didn't you?
I did. And I'm tired.
So I guess in terms of the use of force, primarily what you're here for, the use of force, how long exactly were you part of the training, training unit, if you will, for use of force with your department?
So assigned specifically to that role, I, again, did a number of iterations within the training division, both as just a training officer as well as supervising that division. Throughout that time, there was, so there's 3 periods of time during my career where I was specifically involved in training officers related to the application of force. And that ranges through all force options that officers generally have within the industry. Officers have a variety of force options which are available. And so they exist on a spectrum ranging from low-level applications of force all the way up to what we term deadly force. And so you have essentially empty hand techniques at a lower level of force, which is essentially is things to overcome low levels of resistance that an individual may be demonstrating, like resisting being placed in handcuffs, resisting an officer's attempts to stop their freedom of movement, things of that nature. And in addition, going forward from that, there's another type of empty hands, which is kind of classified as like a hard hands, which would be like hard strikes. And those things are used, again, more for higher levels of force, where a subject may be demonstrating combativeness or aggressiveness towards an officer. All those things together fall into a category of what is commonly termed in the industry as defensive tactics. And so defensive tactics, once you get out of defensive tactics, then you start getting into officers' actual tools that they have available. Generally speaking, the most common tools employed by policing within the United States are OC spray, commonly sometimes referred to as pepper spray. Then from there, you have a baton. There's different types and makes of batons, but essentially batons kind of fall under the same category. From there, you have electronic control weapons. The most common one within the industry is the TASER, which is a proprietary electronic control weapon made by Axon. You also have canine deployments as well, where officers sometimes will use canines that are trained specifically to be used in force applications. And then in addition to that, you have deadly force, which is the most common form of, or the most common way that officers are taught to employ deadly force is through the use of their firearms. So again, these exist on a spectrum. And so in each one of these areas, I was responsible during my tenure as a use of force trainer and investigator to develop policies related to these things that are consistent with current industry practices and standards, as well as to develop a training curriculum for officers so that they could develop core skill competencies in these areas.
Now, in terms of training, did you only train officers in your New Mexico department, or have you been involved in training other officers as well outside of your department?
So since approximately 2007, I have in addition to practicing in law enforcement, I am a full partner in a training and consulting company, Progressive Combat Solutions. My partner is Kenneth Good. He's a former Navy SEAL. And we have trained thousands of officers, both at the state, local, federal level, all across the country, related to these areas, use of force. Primarily what we're known for is training officers in the area of tactics related primarily to generally what a SWAT team or a specialized unit would do within law enforcement. In addition to that, I've been retained by other agencies to assist them in use of force policy development, as well as teaching administrators how to review force applications within their agencies to make a determination of whether or not the actions of their officers were consistent or inconsistent with their organizational policies. And so my work has, again, taken me beyond just my local police agency that I work for.
Okay. And now in terms of when you talk about doing the different trainings, can you give an idea how many times, I mean, with your department, outside of that, how many different trainings can be done for various officers across the country? Ballpark.
I don't know if I could even ballpark it. Numerous, like I said, since 2007. I know thousands of officers. I would say less than 50, somewhere between 30 to 50 agencies. And again, when we conduct trainings on my specific CV, you won't see that many trainings outlined, but at these trainings, they're typically regional. So we'll have officers that will come from, up to a dozen different agencies that will send participants there.
Okay. Just in terms of, you talked also about doing use of force, like 200 use of force reviews. Were those use of force reviews simply for your department, or those other use of force reviews?
The 200 use of force reviews that I conducted were for the department, approximately 200. Outside of that, since 2020, I began having attorneys and police organizations reach out to me and ask me to review cases involving police officer force applications. To date, I've been involved in I've been retained in, I believe it's somewhere around 24 cases that I've testified in all across the country. And so, again, these are outside or beyond just my work that I did.
So, just so I understand, because the 200 were just within your department originally, and then there's 24 on top of that?
Yes, 24 where I was actually retained as an expert witness.
Gotcha. In terms of the 200, when you're looking at your department, what were you looking at for specifically that was part of your job? What were you looking for in those instances?
So when you're conducting force reviews, I think it's important to understand that there's different types of reviews that are being conducted. When you are looking at an agency, you're essentially conducting a review to determine whether or not the officer's actions were consistent or inconsistent with organizational policy. And so that was my primary focus while conducting reviews for the Farmington Police Department. That's also what I trained other agencies to do as well. Beyond that, when you start getting beyond that, again, there's different standards that you could review a case. In my work as an expert witness, that review is essentially to determine whether or not the actions of an officer were consistent or inconsistent with generally accepted police practices.
Okay. And could you go into that? We've heard a little bit, but what are your definition of generally accepted police practices? How would you define that, and where does it come from?
So if you look across the country, there's approximately 18,000 police agencies within the United States, nearly 1 million officers. And so within the industry, there are generally accepted practices where essentially anywhere that you go in the country, you will see similar practices in the way that officers are taught to apply force, as well as the training that officers go through. One of the most common examples I could probably give you would be something like a traffic stop. It doesn't matter where you go in the country. If you see an officer conducting a traffic stop, the techniques, the tactics that officers employ are essentially going to be similar anywhere you go in the country. The way that this information gets disseminated across the country traditionally within the United States, this was done through just sharing trade knowledge. And so officers would essentially, through experience, begin to share trade knowledge with one another. Eventually you had more legitimate trade publications that would come along within the industry that would share essentially this type of information. From there, you started to have expert bodies that began to opine on generally accepted police practices. For example, the most well-known and prolific entity within the United States is the International Association of the Chiefs of Police. They're over 100 years old. They're well respected within the industry, not just nationally, but internationally as well. They provide things such as model policies, as well as a number of recommendations related to training and standards that law enforcement agencies can adopt and utilize to make sure that they're operating, again, in compliance with generally accepted police practices. From there, you have other entities, including the Department of Justice. So the Department of Justice has an enforcement arm where they essentially are able to investigate police organizations where there have been complaints of essentially patterns and practices of unconstitutional policing conduct. And so the DOJ can go into these agencies, essentially conduct an investigation. If they determine that there are deficiencies by that agency, that again, they're not meeting generally accepted police practice, that would legitimize them as conducting constitutional policing, they will essentially sue them and can place them under consent decree. They always keep this stuff very transparent. You can go online and you can look up any of the consent decrees that agencies have been placed under. Where I did my law enforcement career in the state of New Mexico, Albuquerque Police Department was placed under consent decree in 2012. The interesting thing about the Albuquerque Police Department consent decree was, unlike other consent decrees in the past, this was the first time that the DOJ heavily cited use of force issues in policing, and essentially what they held Albuquerque PD accountable to was a signal to the whole industry that those standards are essentially what the DOJ considers the industry standard for constitutional policing as it relates to the use of force.
Okay. Now, I guess in terms of, does that, because you retired, you said you retired, and you were retired for a few years, and now you're doing compliance things with the hospital or nonprofit hospital. Mm-hmm. Do you keep up to date then? Is that how you keep up to date, is reading consent decrees, or are there other ways you keep up to date in the use of force area since you kind of retired from a police officer as a police officer?
So I continue to stay up to date. I'm presently still practicing in law enforcement. There's a small agency within the area where I reside. It's named after me. It's the Bloomfield Police Department. It's not, but
they didn't name it after you joined it there.
No. But I am a reserve officer. And so through that, I still continue to practice. I volunteer my time and assist agencies, but also through doing work like this. I keep up to date, again, with the generally accepted practices through continuous review of trade publications. Like I said, there are trade publications that are used heavily in the industry. One example is Police One. They've been prevalent in the industry for many years. And again, that's a place where a lot of trade knowledge is shared. In addition to that, I continue to follow IACP as well as my colleagues that are also expert witnesses. We have essentially a large group communication where anytime there's new research or things that is coming out involving police standards or police use of force, we typically start a dialogue and see if that information impacts the way that we do this work. So,
At this time, I move for his admission as an expert in generally accepted police practices and use of force tactics.
An expert in generally accepted police practices, Ryan?
Maybe just police practices. I probably kind of got my head around. Police practices and defensive use of tactics.
I'm sorry. First you said use of force in police practices, but you meant...
Sorry?
You said you moved for his admission as an expert in use of force in generally accepted police practices.
Police practices.
And then you said police practices in tactical something.
In a long day. So just police practices and use of force.
Okay. Any objections?
Limited to that, Your Honor. Can I ask a few questions? Can I invite you to witness?
Okay. About his expertise.
Yeah, so just before I... Good afternoon. I understand you had a heck of a time getting here, so I appreciate, we were all wondering if you were going to show up with a suit and tie on. So we would have forgiven if you had showed up in jeans and finishes.
Thank you.
So police practices,
Mhm.
you're an expert in police practices, not GRPD police practices, right? GRPD is Grand Rapids Police Department.
Say that one more time. I am an expert, I think I'm tracking, I am an expert in generally accepted police practices, yes. Specifically GRPD, I would say no.
Okay. And same question for use of force policies. You're an expert on the use of force in relation to generally accepted police practices, but not necessarily specific to Grand Rapids Police Department?
That is correct. What I will state, just to add a qualifier there, is that during my review of the materials in this case, I was provided the policies of the Grand Rapids Police Department related to use of force, and I determined that the policies of the Grand Rapids Police Department are consistent with generally accepted police practices.
Oh, all of them?
The ones that I reviewed, yes.
So you didn't review every single policy?
I can't recall right offhand every single policy I reviewed, but the ones that were provided to me.
Okay. All right, Your Honor, with that caveat, you may proceed, we don't object.
All right, then he shall be considered an expert in those fields of use of force in police practices.
You were hired specifically to review this case, correct?
That is correct.
Do you recall approximately when that was, when that took place?
I don't recall it after
It's been a few years.
It has been a few years, yes.
What do you do when you get hired in to take a look at a case? What transpires? How do you start that review?
So generally speaking, all these cases involve some type of preliminary discussion where I'm essentially provided a brief synopsis of the case. There may be a discussion as far as where I provide my CV and what type of expertise I can offer. If an entity decides to retain me through a formal retainer, at that point I'm provided materials. Materials varies based upon the organization. I've had some cases, and again, sometimes this is just due to the nature of the incident itself. Some incidents simply consist of just reports by officers of witnesses, or there's no video, there's no additional information. Others, there's extensive multimedia in the form of video, audio recordings, things that can assist in the review. So it varies from case to case. But essentially, I rely on whichever entity is retaining me to provide me with the materials. I take those materials and I conduct an extensive review. My purpose in the review is to try to essentially determine what the facts are within the case. Once I have the facts laid out, I typically go back and to those who have retained me and essentially just go through to make sure that my understanding of the facts is consistent with their understanding of the facts, so that we're all on the same page. And then from there, I'll begin to formulate opinions based upon the actions of either a solo officer, or sometimes these incidents involve multiple officers. And as I work through these opinions, what I'm doing is I'm comparing again the actions of the officers to generally accepted police practice. And what I'm basically stating is whether or not the actions of the officers are consistent or inconsistent with generally accepted practice.
Now, you talked about some of the things you reviewed for this case. Some of the things that you did review would be the videos.
And that is correct.
What videos do you recall that you specifically reviewed?
There was a couple of videos. There was a video that was captured by the officers in-car camera. There was body-worn camera footage that was also captured by the officer's body-worn camera. And then there was cell phone footage that was captured by a bystander.
Okay. I'm going to go into, maybe start out, we switch it to our side. Try exhibit 2, please. Exhibit 2. You did one, please. There should be a laser pointer right up there for your Now, in terms of, do you recall viewing this, would be People's Exhibit 2 at right about 2:02 of the time frame. Do you recall reviewing this video?
I do.
This would be the in-car video.
It appears to be the in-car video, yes.
Now, in terms of use of force, you talked about some uses of force. I'm going to play this for you a little bit. Stop right there. Yeah, you talked about techniques. Now, the techniques here, what techniques did you see that were being used specifically in this instance?
So a couple of things here. When it comes to officers applying force, there's essentially two kind of categories. There are improvised techniques, which are essentially untrained techniques or techniques that an officer, where it doesn't mean that those techniques are not reasonable to be used, but at the same time, they're not necessarily formally trained, like in a defensive tactics setting. And then there are techniques that officers are generally trained in. So I see a combination of those two things. So let me give you an example of an improvised technique. If an officer is engaged in a foot pursuit, in order to terminate that pursuit, they may choose to essentially tackle the individual that's fleeing from them. I don't know of any law enforcement agency that trains officers to tackle formally because, again, the likelihood of injury would be too high in most cases. However, when you look at proportionality as far as the level of resistance that an officer is witnessing, that could be absolutely reasonable. It's just not formally trained. As far as what I see as being formally trained here, is the officer in this particular instance is applying some knee strikes. Knee strikes are a commonly taught defensive tactics technique within the policing industry. Knee strikes can be used defensively, so they can be used by an officer to essentially protect themselves if they are being attacked, but they can also be used to overcome levels of resistance. And so in this particular case, the officer appears to be in a position where he is essentially on top of Mr. Lyoya. In this particular instance, attempting to keep Mr. Lyoya down on the ground. Mr. Lyoya is clearly being successful in being able to rise to his feet, and so the officer is electing to use knee strikes in this particular case. It's difficult to see where those knee strikes are being applied. Generally, in order to overcome a level of resistance, knee strikes are generally taught to be used by officers to target essentially the lower extremities, like the thighs and those areas. Again, because it's not being used necessarily in self-defense in an instance similar to this one, it's being used to overcome that resistance. And so I see the application of a couple of knee strikes here, which appears to be targeted to the lower extremities.
And so that would be typical. There's nothing untoward about it. There's nothing wrong with that. That would be a typical thing that you would teach as a use of force.
Yes, based upon this video and based upon, again, the way that officers are taught this technique and how to deploy it, I would say that an officer in this situation, that this application of force would be reasonable and consistent with generally accepted police practice.
Maybe focus on a little bit more. I'm going to stop it here, Your Honor. Yep, this is Exhibit 3. I'm going to start right about 2 minutes, I think. I can't read. 2 minutes. Now here, a little bit more focus on the hands. You can see the hands. Can you describe for the jury what they're seeing here?
So in this instance, the video appears to show that, again, Mr. Lyoya is down on the ground. He's attempting to get to his feet. The officer is on top, attempting to control him. So it's common within the industry that officers are taught defensive tactics related specifically to working with individuals on the ground who are demonstrating resistance. Again, you have two different areas on the spectrum. One is to overcome resistance, the other may be defensive. So recently, within the last, since I've been in law enforcement over the last 20 years, grappling, jujitsu, those techniques have been heavily adopted within the policing industry all across the United States. The comprehensiveness of an officer's training in that area may vary, but at the same time, officers are taught grounded techniques of how to control subjects who are resisting, as well as how to actually defend themselves if they find themselves under attack, well grounded. Here in this particular instance, everything that you see in terms of hands being placed to attempt to keep Mr. Lyoya on the ground, I would classify this as essentially, again, just techniques that officers are generally taught. A little bit of improvisation also appears to be occurring here, but the positioning and everything that the officer is attempting to do, again, I would state that an officer in this instance, that all of these applications of force in an attempt to keep Mr. Lyoya on the ground would be reasonable and consistent with generally accepted practice.
Now, we're going to move along a little bit. At some point in time, there's a TASER introduced. Is that a fair statement?
Yes.
I think we're still in Exhibit 3, right? Okay, there's a TASER introduced. Could you give the jury a little bit in general, in training and generalized general police practices? When do you introduce a weapon? Is there any criteria? Can you give a jury an idea of what goes through that?
So, as I briefly talked about during my initial questioning, officer use of force exists on a spectrum, and so officers have many force options that are available to them to overcome resistance. I need to talk just a little bit and lay a little bit of a foundation in terms of how an application of force, what essentially allows an officer to make a decision from going from a lower level of force to a higher level of force. So the first thing is proportionality. And proportionality, we primarily first want to talk about levels of resistance or aggression that may be exhibited by an individual. So when an officer has essentially a valid legal reason to detain an individual, whether that is to detain them to investigate a crime or to detain them, essentially taking them into formal custody, if an individual resists the officer's actions, the degree of resistance that they exhibit is what opens up the options related to an officer's use of force selections. And so at the lower end, if an individual is displaying a low level of resistance, maybe they're passively, or they're walking away from the officer after the officer's told them that they're not free to leave, or they attempt to lay hands on an individual, tenses their arms, flexes, pulls away, things of that nature. That would be low-level resistance. And the thing is, again, I think it's important to understand that the term resistance is key. Resistance does not suggest that an individual is trying to harm the officer, but they are simply, trying to resist an officer conducting a lawful objective. And so from there we get into what would be constituted as aggression, where somebody is actually physically trying to harm an officer. Harm can come in all different ways. Physical assaults, an individual could attempt to use a weapon on an officer, things of that nature. So then when you get into that area, now we're looking at much higher levels of force that would be appropriate to be used. And then eventually we'll get to the application of deadly force. In this particular instance, so when electronic control weapons, and this is a TASER 7, this is the same model of TASER that I carried towards the end of my career. The TASER, when it initially arrived and became prolific, it was in the early 2000s roughly, and it became more and more common within the policing industry. The TASER has a couple of different options available with it. So first and foremost is the proprietary nature of the TASER that Axon developed was the TASER was capable of achieving what is known as neuromuscular incapacitation, or NMI. Essentially, NMI, if you've ever seen somebody actually be tased with a TASER, it manifests that NMI has been achieved by watching somebody essentially lock up, where essentially they've lost motor control for the period of time when they are under a cycle of the TASER. And again, this is going to get a little detailed, but it's important I have to again lay this foundation so we can understand when the TASER would be appropriate to be used and where it kind of lies as a force option.
Objection, Your Honor. This is all about expertise in tasers, and I don't believe you've been qualified as an expert in tasers.
It's not about tasers, it's about what he just said, when the tasers are appropriate as a use of force option. So he's trying to talk about when a taser can't be introduced. He's not talking about the specific instances of taser, it's just when it should be introduced in the spectrum of what an officer has.
Okay, so I'll overrule the objection because I do believe he's testifying about it in the use of force context. You may answer that question.
So yeah, just going into it in terms of, trying to get into how is it determined appropriate when you have other options, baton, OC spray, taser.
So going back to the TASER, so the TASER is capable of achieving neuromuscular incapacitation, or NMI. In addition to that, it also has the ability to not create NMI, but essentially operate off of the principle of pain compliance in what is commonly referred to as drive stun mode. So if you essentially remove the cartridge or the multi-cartridge from a TASER, this particular model of TASER has multiple cartridges. There are essentially probes that are on the end of the TASER where essentially you can contact somebody with that, pull the trigger of the TASER, and it'll cycle. This is not achieving neuromuscular incapacitation. This is just achieving pain sensation, and so it's known as pain compliance. OC spray also operates off of the principle of pain compliance. And so when an officer applies OC spray, it's essentially you're relying on how susceptible the individual is to that burning sensation in terms of how effective it's going to be. So you may have individuals that are sprayed with OC spray where it's highly effective. You may have individuals where it's as if nothing happened. And so just wanted to clarify that those are kind of the two different ways that this tool can be used. There's kind of a third one, which I won't get into. But essentially, at the lower level, because drive stuns operate off of the principle of pain compliance, that is considered a lower level application of force than a full probe deployment. So when an officer actually has a cartridge attached, there's two probes that fire out of the end of the cartridge. Those probes, if there is a successful spread in those probes, that's the highest likelihood that NMI may be achieved. And again, it's not always a guarantee. There's a variety of things that could happen that could impede NMI from actually occurring. But when you see an officer deploy the TASER in probe mode, the goal or the intent is that NMI is going to be achieved through that. And the other thing is that what probe mode allows you to do versus drive stun mode is you can actually attempt to energize a subject from a distance. Okay, depending, these cartridges come in different lengths, and so you have 21-foot cartridges. You can get longer cartridges, which are sometimes used for specialty situations. So again, going back to when it is appropriate. So an individual that is demonstrating active resistance towards an officer. Now, here's where I'm going to talk a little bit about differences in industry standard. There are officers throughout the country which train officers, and it is also within their organizational policy that a drive stun can be used to overcome lower levels of resistance, again, operating off the principle of pain compliance. When it comes to the actual application of the TASER in probe mode, again, that can be used for higher levels of resistance. And in this particular case, what makes this decision of the officer to deploy the TASER appropriate is the fact that the officer, has already used other lower levels of force in the form of what we've already seen, empty hand techniques, trying to keep Mr. Lyoya on the ground, knee strikes, things of that nature, and those things have failed. And so there is a principle in policing where if a lower level of force, and this is generally going to be within the spectrum of all levels of force that are less than deadly force, that if those levels of force fail and the individual is continuing to display resistance, the officer can escalate their application of force, which appears what is happening in this particular instance. And so again, an officer in this case choosing to deploy a TASER in probe mode, although I would say that the method of deploying it is tactically unsound, but the decision to actually utilize a TASER would be consistent with generally accepted police practice.
In terms of, you talking, are OC spray and TASER, you talked about the same thing. Are they on the same level, I guess, of force?
They are not. They are not. But again, let me clarify that when you talk about the TASER being utilized in drive stun mode, not in probe mode, the drive stun mode, because it operates off the principle of pain compliance, could be categorized essentially alongside OC spray in that sense. Generally speaking, TASERs are considered a higher level of force application because the intent of the manufacturer, as well as the opinion of expert bodies within policing, a probe mode deployment is considered a higher level of force on the spectrum than OC spray would be.
Okay. Now you mentioned though the decision made to use the TASER is appropriate within the spectrum, but tactically there's an issue here. What do you mean by that?
So when it comes to the application of force, but also when it comes to police activity in general, police throughout the nation are essentially taught tactics. Tactics fall under what we generally categorize as officer safety. And so essentially officers are taught in the basic academy, and this is consistent all across the industry, where officers are provided common tactics of how to safely go about accomplishing their lawful objectives. I mentioned traffic stops earlier. Everything that an officer does, from the positioning of their vehicle to where they choose to make a stop, if it's within their power to do so, to the way they approach a vehicle, that is all done with purpose and intent. And done so to not just protect the officer, but also to protect the individuals that they're contacting, as well as other bystanders that may be in the area. Essentially what we talk about when it comes to police working and accomplishing their objectives, there's always risk involved, right? There's always risk involved in this type of work. However, through sound tactics, if officers rely upon sound tactical principles in the way they go about conducting their work, they can prevent risks from manifesting as threats, and from threats, if there is a threat present, potentially manifesting as harms to the officer or others. And so again, tactics are very key in this whole conversation about the application of force. So in this particular instance, the issue as far as, well, the selection of the TASER was an appropriate selection and an appropriate option at this point to overcome the level of resistance that was being demonstrated by Mr. Lyoya. Officers are taught within the tactical arena as well as in defensive tactics something that we term weapon retention. So weapon retention is a key principle where essentially if you're going to employ a tool on an individual, part of your calculus in choosing to deploy that is you also want to make sure that that tool cannot be taken from you and potentially used against you or others. This is really prevalent when it comes to police firearms. There are many case studies out there where officers have been killed with their own firearms, have been successfully disarmed. This also applies to every other force option that an officer has at their disposal: OC spray, baton, TASER, etc. And so officers are taught techniques and tactics to essentially retain and keep their weapons. In this particular instance, there's two things about the TASER deployment here. If the TASER is going to be deployed in probe mode, the manufacturer, and this is common in, because the training that officers receive as far as as TASER goes is consistent throughout the industry, because TASER actually provides the training to police agencies. And so according to TASER themselves, in order to have the greatest likelihood that when the probes are deployed that you're going to get a far enough spread apart and get what they essentially term splitting the hemispheres, which is where you have a probe, the belt line, you view the waistline as the hemisphere. Having a probe, one probe above and one probe below in large muscle masses is going to give an officer the highest likelihood of achieving neuromuscular incapacitation. In order to get that spread, you have to have distance between you and the target. And so generally speaking, that distance, again, needs to be, what TASER recommends, roughly 7 yards to get that accomplished. So two issues here is deploying a TASER this close when the environment does not force an officer to have to deploy the TASER this close, meaning that in a confined space where the environment precludes an officer from being able to create space to do this. That's one thing, but that's not this particular instance. The officer has the ability to create distance. And
Let me stop you right there real quick.
Yes.
And I just want to get into that distance aspect. Is distance only with the TASER, or are there other things in police defensive tactics where distance is important too?
So distance is always important. It is one of the largest factors when it comes to these type of confrontations. Time and distance are the two biggest factors. So we talk in policing, it's not always about creating distance, it's about creating the right distance. Sometimes the appropriate answer is to close distance. Sometimes the appropriate answer is to create distance. Depends on what the force option is. It depends on what the situation is. Officers are also taught that if they are in a situation where they're applying force, and generally this happens solo, if they are unsuccessful in overcoming an individual's resistance, and they are essentially failing to overcome that resistance, sometimes the best option is what we refer to as a tactical retreat, where we create more distance, we keep eyes on, we summon more resources. That could be an option. The other thing is if an officer is being attacked, if they have the ability to create distance, they can do so. And so again, it's multifaceted in terms of what may determine that.
So then so going specifically for this instance, so it's distance not only for the TASER, but there's also distance just in general for police practices.
Correct. And so in this case, by creating distance, that would allow two things to happen. One would be there'd be a higher likelihood that neuromuscular incapacitation is going to be achieved, because now we're at a appropriate standoff distance recommended by the manufacturer that's going to give us the greatest likelihood of achieving NMI. Number two is I'm also, by creating distance, I am preventing anybody from grabbing a hold of the TASER, so that's also the best option because it's the most tactically sound option. And so that's why the failure to create distance in this particular case is tactically unsound, although the decision to employ the TASER was reasonable.
So disengagement is part of police training. Is that part of police training and generally accepted police practices?
Yes, it is.
It's not a matter of you being a coward or running away or, you know.
No, what we find statistically speaking, again, is when an officer essentially is in a situation, and again, it depends on the circumstances, right? So let me qualify this by making the statement that the highest priority that American law enforcement has is the protection of life. That is the highest priority. So if you have a situation such as an active shooter, an active killing event, officers are taught to close the distance immediately with haste to essentially locate pressure and stop the action of the shooter or whatever it is that's preventing imminent threat of harm to life being lost. That just doesn't fall on the part, that just doesn't mean officers, that also means bystanders. In addition to that, officers are also concerned about preserving the life of the individuals that are resisting them, that they're attempting to take into custody, or that are involved in some type of law enforcement action. And so what we find is that, again, because we have enough data points within the industry and enough experience within the industry, we know that sometimes a tactical retreat is actually the safest option for the officer. It's also the safest option for the suspect. It's also the safest option for bystanders. And again, sometimes you get into a situation where, you know, for lack of a better term, you may be in over your head where you don't have the resources to safely do this alone. Foot pursuits are a big example. It used to be in the industry that you know, foot pursuits were very commonplace. Officers would take off solo, and we had a lot of instances of officers being seriously injured or killed, as well as suspects. Now, the generally accepted practice, and again, this has been recommended by all kinds of expert bodies. It's very common within the industry. The officers need to make a good tactical decision as far as when to pursue and engage in a foot pursuit, particularly solo. That would depend on the nature and severity of the crime. Sometimes it's just not worth it for low-level crimes to initiate in a pursuit, especially where officers may be placed in greater jeopardy by initiating that pursuit. Officers are taught as another option to essentially keep eyes on, continue to follow from a distance, but to summon other resources and essentially close in and wait till other resources arrive. And again, what we find in those cases is a reason why that direction has changed in the industry is because we find that officers, suspects, and bystanders are safer as a result of that type of disciplined decision-making.
I'm gonna actually see it's 1:45, I can see the clock, so.
Yeah, so we're gonna stop here and resume to trial morning at 9 a.m. And so meanwhile, jurors, please again leave your notes upside down in your seats, and remember to not discuss the case with each other or with anyone else. And also avoiding media reports about this case and